What's up, y'all? Welcome back to Out of the Darkness. I am Q. So one of the main jobs that I feel that I have with this channel is to bring information that is not being covered in the mainstream media. Information that is profoundly important to we patriots, to we Americans. And so I wanted to bring you guys some hope. Project Veritas is in a fight for the ages, of the ages, for America, for the soul of America. They are taking on, James O'Keefe is taking on one of the largest powers in the mainstream media, and that is the New York Times. And it's getting absolutely no play from the mainstream news media, which I understand because they are trying to protect their own. I'm going to read this to you. I know it gets a little monotonous me reading, but I think it's important because I don't want to miss anything, and I think it's important that you get the full context. I'll try to go as smooth as possible, but I'm going to work through it, okay? While it has received little coverage in the mainstream media, the conservative group Project Veritas won a major victory against the New York Times this week in a defamation case with potentially wide reach. In a 16-page decision, the New York Supreme Court Justice Charles Wood ruled against the newspaper's motion to dismiss and found that Project Veritas had shown sufficient evidence that the New York Times might have been motivated by actual malice and acted with reckless regard in several articles written by Maggie Astor and Tiffany Sue. The decision will allow Project Veritas to discovery, which can be extremely difficult for news organizations. Notably, this follows another significant loss by the New York Times to Sarah Palin last year. I don't know if you guys heard about that, but Sarah Palin did have a case against New York Times and won. Having two such losses for the New York Times in the defamation area is ironic given its role in establishing the precedent under New York Times versus Sullivan. The case came out of a highly divisive period of the civil rights movement. The New York Times had run an advertisement referring to abuses of civil rights marchers and the arrest of Martin Luther King Jr. 7 times. The Montgomery Public Safety Commissioner, L.B. Sullivan, sued for defamation and won under Alabama law. He was awarded $500,000, a huge judgment for the time. Sullivan's lawsuit was one of a number of civil actions brought under state laws that targeted northern media covering of the violence against freedom marchers. The judgments represented a viable threat to both media and average citizens in criticizing our politicians. The Supreme Court ruled that tort law could not be used to overcome First Amendment protections for free speech or the free press. The court sought to create breathing space for the media by articulating that standard that now applies to both public officials and public figures. The status imposes the high standard first imposed in New York Times versus Sullivan for public officials, requiring a showing of actual malice where media had actual knowledge of the falsity of the statement and showed reckless disregard, whether it was true or false. In this case, Astor and Sue were accused of libeling Project Veritas by stating their opinions as fact in the articles on video clips that purportedly showed illegal voting practices by campaign workers for Congressman Ilhan Omar, the Democrat out of Minnesota. One article by Astor on September 29th was titled "Project Veritas Video Was a Coordinated Disinformation Campaign, Researchers Say," and reported how academic researchers found the video to be part of a concerted disinformation campaign. The article describes the project's work as deceptive. Sue followed up a month later with a story titled "Conservative News Sites Fuel Voter Fraud Misinformation." That again quoted academic experts in describing the work as deceptive and part of a propaganda feedback loop. Other articles follow a similar narrative. The opinion is interesting because it calls out the New York Times for blurring the lines between opinion and fact. And it is a common complaint as major news media yield to the echo chamber model of journalism, appealing to the bias of readers or viewers in offering slanted coverage. The court calls out the newspaper for such blurring, including this excerpt. In similar style, the Fox News host Sean Hannity and conservative publications magnified the reach of a deceptive video released last month by Project VERITAS, a group run by conservative activist James O'Keefe. The video claimed without named sources or verifiable evidence that the campaign for Representative Ilhan Omar, a Minnesota Democrat, was collecting ballots illegally. The issue is whether Project Veritas should be given a chance to prove its case in court, and found that it should. Actionable assertions of fact are tightly intertwined, with what defendants now characterize as opinion. In part, defendants argue that their statements describing Veritas' video as deceptive, false, and without evidence were mere opinion, incapable of being judged true or false. However, if a writer interjects an opinion in a news article and will seek to claim legal protections as opinion, it stands to reason that the writer should have an obligation to alert the reader, including a court that may need to determine whether it is fact or opinion. That is opinion. The articles that are the subject of this reaction called the video deceptive, but the dictionary's definition of defamation and deceptive provided by the defendant's counsel, document 14 at footnote 29, certainly applied to Astor's and Sue's failure to note that they injected their opinion in news articles, as they now claim. Likewise, defendants now appear to assert that the promotion of the video was where the deception was. But there is a difference between viewing a disappointing fight of the century and reporting that it was not worth the pay-per-view fee or did not live up to the hype, and reporting to the public that the pay-per-view knowingly marketed a fight that was fixed. Plaintiff is entitled to try to establish whether the New York Times writers were purposely and or recklessly inaccurate, or whether they were inaccurate, sloppy, or something less. Note that this is not a finding of actual malice, but it will allow the project to plunge into discovery, including depositions and possibly a trial. The New York Times also attempted a Hail Mary claim that Project Veritas was libel-proof. We have previously discussed such claims as very hard to establish. The court correctly and quickly dispensed with that claim by the New York Times. The Second Circuit has played a significant role in this area as well, due to its foundational 1975 opinion in Cardillo versus Double Play and Company Incorporated. That case concerned a book, My Life in the Mafia, that accused the plaintiff, Robert L. Cordillo, of various crimes. Cordillo had a long record and was serving time in the federal penitentiary. The Second Circuit affirmed that dismissal of the case because it considered as a matter of law that appellant is for purposes of the case libel proof. These are extremely rare rulings, and in my view, being Jonathan Turley's view, the use of a defense in this case is a mistake. There is a tendency in litigation to throw everything at an opposing party and let the court sort it out. It may be cathartic, but it can be costly. In this case, the newspaper likely lost credibility with the court and highlighted the alleged bias in claiming that this conservative investigative group has no reputation to lose. It is the type of claim that is highly unlikely to succeed, but as a high likelihood of undermining other claims in the motion to dismiss. In the end, the court finds that there is sufficient evidence of actual malice by the New York Times to proceed in the case. The court finds that the documentary proof and facts alleged by Veritas are sufficient to meet its burden. The facts submitted by Veritas could indicate more than standard garden variety media bias and support a plausible inference of actual malice. There is a substantial bias in law to proceed to permit the plaintiff to conduct discovery and to then attempt to meet its higher standard of proving liability through clear and convincing evidence of actual malice. Malice focuses on the defendant's state of mind in relation to the truth or falsity of the published information. Here, there is a substantial bias in law and fact that defendants acted with actual malice, that is, the knowledge of the statements in the articles were false or made with reckless disregard of whether they were false or not. Veritas alleged that malice by providing facts sufficient to demonstrate defendants' alleged disregard for truthfulness of its statements. Accordingly, at the very early stage of litigation, Veritas' submissions were sufficient to withstand defendants' motions, and further proceedings are necessary to resolve the issues raised. The opinion could have proved a critical shot across the bow for many in the media that are blurring opinion and fact. This is important and come at a high price. Notably, the New York Times argued that there was nothing wrong with the articles because the reporters were stating their opinions. Project Veritas noted that the paper's own ethical policies prohibit news reporters from injecting their subjective opinions into news stories. The effort to argue that reporters can interlace facts with opinions reflects a broader discussion of how journalism is changing. Recently, columnist Andrew Sullivan, who was himself the target of a canceling campaign for expressing opposing viewpoints, criticized the media for emphasizing narratives over news. Indeed, we have discussed how journalism professors have publicly called for an end of objectivity in journalism as too constraining for reporters in seeking social justice. This trend towards advocacy journalism has led to polls showing record lows in terms of trust for the media. The cost of the changing view of journalism may not only be in loss of core trust, but of core legal protections. The New York Times obviously could still prevail in this case. However, It is now facing difficult months of discovery absent a reversal of this decision. The actual malice standards is a great protection for the media. However, once a court finds a basis for the allegation, a wide array of evidence become material, including the confidential communications between reporters. Can some of these sources or sub can some of these reporters can some of these sources or subjects that can lead to drawn out litigation over confidentiality and demands for ex parte in camera views by the court. Jonathan Turley then says, I expect to be teaching this case next year in my torts class when we deal with defamation. Guys, I'm so sorry. I am stumbling and bumbling through it, but it is so important because this right here is going to make life for conservatives so much better. If James O'Keefe can win this case, this sets us up to start disbanding the MSM, the mainstream media as we know it, to force them to start reporting the news and the news only, not interjecting their own opinions into the news and selling them as facts. This was detrimental to our president. This has been detrimental to the United States. And it is the reason why we've seen the rising of organizations like Black Lives Matter and organizations like Antifa, because they're being sold a bill of goods by a very dishonest mainstream media. So I will keep you guys up to date on this. Make sure you guys pay attention and see what's going on, because this is going to be the fight of our generation. Dismantling and disbanding the way that mainstream media handles its consumers is going to be so important moving forward. Let me know what you guys think about this. Make sure you comment below. Sorry it took so long, but it was really important and way too important to just brush over it. So have a fantastic day. I'll see you next time.